CCE, the Center for Continuing Education, is a State Bar of California MCLE approved provider. CCE certifies that this program is approved for MCLE credit. CCE, the Center for Continuing Education presents Personal Injury for the General Practitioner, presented by Dennis E. Simmons. Dennis E. Simmons is the managing partner of the Simmons law firm, San Rafael, California. Prior to founding the Simmons law firm, he had been partner at Morozumi and Simmons, LLP, an insurance defense firm which focused on accidents arising in the transportation industry, particularly buses, trucks, and limousines. He has particular expertise in explosion, fire, and bus and trucking litigation. Mr. Simmons has extensive experience representing both plaintiffs and defendants in bench and jury trials throughout California. He has represented clients in over 200 arbitrations and mediations and numerous administrative hearings. During the past decade, he has continued to specialize in civil litigation, but his practice has also broadened to include business law. In this area, his clients include numerous small businesses and sole proprietors in the Bay Area. From 1992 to 2008, Mr. Simmons served as an adjunct professor at San Francisco Law School, teaching courses in contracts and sexual harassment. He has served as an arbitrator in the San Francisco Bar Association's Attorney-Client Fee Dispute Resolution Program since 1998, and currently volunteers as a mediator in Marin County Superior Court's Bench Bar Settlement Program. His firm's website is www.simmons-lawfirm.com, and he may be reached by email at dsimmons@simmons-lawfirm.com.
This seminar is Basic Personal Injury for the General Practitioner. There will not be a significant discussion of trial tactics, but rather considerations that are imperative when you are beginning to evaluate a personal injury case, as well as basic do's and don'ts throughout the process pre-litigation. My name is Dennis Simmons, and I've been practicing law in California for approximately 22 years. During this period of time, I have litigated approximately 1,000 cases, the majority of which were personal injury cases. These cases have ranged from products liability to cases against governmental entities, wrongful death cases, and numerous cases involving vehicular collisions, including trucks, buses, limousines, and, of course, automobiles. For the sake of simplicity, this seminar is primarily geared towards the automobile case. In other issues, other types of cases, such as trip and falls, slip and falls, there are other considerations that the practitioner will want to consider. However, for this seminar, we're really focusing on the auto case. Now, the initial question is, what do you do with your initial client contact? Typically, the initial client contact will come from a referring attorney or a friend of a family member. And this initial telephone conference should be used to ascertain some very, very preliminary facts. Of course, you need to determine why the prospective client has called you. In other words, did it in fact involve an accident? Did it involve a slip and fall, a trip and fall? Was the client injured in an explosion? Most importantly, your threshold question should be, when did the accident occur? Now, why is that significant? Well, if the accident occurred approximately 6 months prior to the initial client contact, you would need to file what's called a governmental tort claim if one of the potential defendants was or is a governmental entity. Failure to file the governmental tort claim within 6 months after the accident may perpetually bar, in other words, through the statute of limitations, the 6-month statute, your client from any recovery whatsoever against a governmental entity. There are, I should add, procedures to seek relief called an application for relief from the late claim procedures. However, you really don't want to take that chance. Similarly, if the client has come to you and you find out in the initial telephone conference that nearly 2 years have elapsed since the accident, well, California, since 2003, has had a 2-year statute of limitation in personal injury actions. In other words, if there is some degree of urgency, you need to act on this matter very, very, very quickly, or you risk a situation involving serious consequences. In other words, your client's claim may be lost. Clients also typically have initial questions relating to medical treatment. Frequently, if the accident occurred within the 2 or 3 days prior to the telephone conference, a client may not have obtained medical treatment at that point. So the client may ask you, what should I do about a doctor? Well, I highly encourage you to tell your client, or prospective client at this point, to seek help from his primary care physician. If, however, the primary care physician is not available for 2 or 3 or 4 days and your client is in some distress, definitely tell your client to seek help from an emergency room at the local hospital. I encourage you not to refer that client to anything involving what might be termed alternative medicine at the early stages. And the reason for that is everything should be orchestrated, if at all possible, through the primary care physician. You should also advise in that initial telephone conference against your potential client talking to the defendant, that is the tortfeasor or adverse driver, from talking to their insurance company. Usually, the adverse insurance company will insist on a recorded statement. Your client is not required to provide a recorded statement to the insurance company. Simply not. And I advise you to advise your client not to provide a recorded or a written statement to the adverse insurance company. Why is that? Well, your client's recollection of the accident is going to vary over time. Despite what we have in California called fast track rules, in which a case is supposed to go to trial within 1 year of filing, as a practical matter, it's very, very common for 2 years or more to elapse from the date of filing until the actual trial date. Regardless of how smart your client is, regardless of your client's recollection, your client will not be able to remember the details surrounding the accident in 2 years. It's simply impossible. Therefore, the recorded statement will provide the defense attorney with fertile ground to impeach your client and find subtle differences and nuances to